everyone, and welcome to today's FSC Connect webinar, Leading Lawyers Australia. I'm Carissa Perano, the FSC New Zealand's Head of Regulatory Affairs. And today, due to the growing member appetite to hear more about what's happening across the Tasman, similar regimes and approaches, and many FSC members with an Australian group or parent, I'm delighted to facilitate a new Leading Lawyers panel today with 4 leading lawyers from Australia, several of which I was fortunate to work with whilst I lived in Melbourne. Today, our leading lawyers will be providing expert views and insights on tackling new and emerging legal and regulatory issues in the financial service sector in Australia, drawing parallels with similar or upcoming regimes in New Zealand. We welcome questions in the chat throughout today's webinar, and we will endeavour to respond to them as they come through. We also have time for questions at the end. So now over to our panel, and firstly, Abby, can you please introduce yourself and your practice?
Hi everyone, lovely to see you all. My name's Abigail McGregor. I'm a partner in the Melbourne office of Norton Rose Fulbright Australia. My practice really constitutes ethical business, so I do a lot of work in relation to business and human rights, and particularly the Australian Modern Slavery Act. But I also do a lot of work with whistleblowers and also in relation to bribery and corruption. Thanks, Carissa.
Thank you, Beth. Thanks, Abby. Over to you, James.
Hi, everyone. Great to be with you this afternoon. So James Dirty, I'm a partner in the intellectual property and technology team here at Hall & Wilcox. And so in my practice, I particularly focus on technology matters, including privacy, cyber and data security matters. So we do a lot of work with financial services clients, particularly regulated financial services clients, on the sort of the whole range of privacy, data and cyber issues that come up for those organisations. So everything from contractual clauses, outsourcing, privacy and data compliance, responding to cyber incidents, and planning for cyber incidents and the like.
Thank you, James. Bart, can you please introduce yourself and your practice?
Good afternoon, everyone. Pleasure to be here. I'm a partner in the Corporate and Capital Markets group of Australasian. So my practice largely deals with regulated mergers and acquisitions, capital markets and financial services, working extensively with, in the main, public companies, stockbrokers and financial intermediaries.
Thank you, Bart. And lastly, we are joined by Harry.
Thanks, Carissa. I'm Harry New, and I'm partner at Hall and at Wilcox in the Melbourne office, and I lead our investment funds practice. As of tomorrow, we'll actually have one of the biggest financial service or funds practices in Australia. We're an independent firm. We have about 1,100 people, and we manage all stages of a fund's life cycle, from licensing, regulation, compliance and investments.
Thank you, Harry, and thank you, Abby, James and Bart. Now for an overview of the Australian market, can I ask each of you, what are the key areas of focus for your firm and clients at present? And also we are keen to know, what are the impacts of the Culture and Conduct Review still being felt? Maybe start with you, James.
Yeah, definitely. I think in terms of the priorities for Hall & Wilcox and as a firm, I think that we're really sort of focused on our clients, unsurprisingly. So we practice in a number of areas, and we have a particular focus on the financial services industry, as well as the technology and digital economy industry as well. And so increasingly, we're doing a lot of work in the sort of crossover between financial services and technology, which I think is a really interesting space. So, you're really seeing a lot of convergence between financial services clients and technology clients. It's kind of that old cliche about every client these days is a technology client, but it's really the case in the financial services space, where obviously it's a very competitive industry. So, technology can be a key differentiator, and it can also be a key risk factor in terms of some of the issues that can come up around cyber breaches. And we're definitely seeing a lot of sort of action in the regulatory space around sort of that data and cyber piece with respect to financial services. So I think that's kind of what I'd say from my perspective. Harry might probably have some specific insights as well.
Over to you, Harry.
Okay. I thought that might. I think just generally, I think from a market perspective, and would be of interest to our New Zealand counterparts, is just I think the general economic environment. So I think capital is hard to come by. I was actually at a regulator or ASIC meeting around licensing this morning, and it was interesting that activity around licensing has definitely dropped off this year, and I think it's a reflection generally of that market. But at the same time, I'm sure everybody's feeling the pinch in terms of regulation because that hasn't slowed down at all, and that's a very interesting dynamic to manage within organisations that are tightening their belts, but at the same time need to deal with significant legislation. But just to rattle off on sort of a list of regulatory initiatives and things that are being worked on, James has mentioned a few around cyber privacy and breaches, but we've got unfair contract terms legislation that is affecting financial services because it's being extended to organisations that it didn't reach before, including financial services, greenwashing and ESG, design and distribution obligations, remediation processes. Our regulator just put out an announcement on that, and also a proposed new regulatory framework for regulating digital assets. So you can imagine it's a full suite of regulation, and I'm sure the others will add to that. Thanks, Carissa.
Thank you, Harry. I think there are similar experiences here also with the regulatory overburden. Abby, what are your insights? What are you seeing?
So we're seeing, much as Harry suggested, a convergence in ESG where issues that were relatively siloed are now combining at a rate of knots. So, for instance, the word sustainable, it now no longer just means environment or climate. It really means human rights. It means nature. It means net zero. It means a whole lot of things. And so we're speaking to a lot of clients about that kind of ESG type elements. The other thing we're doing a lot of is talking about how compliance policies are not enough and they actually need to be implemented, and that you can have a gold standard compliance program, but if you're not implementing it, you're in significant trouble.
Thanks, Abby. And Bart, what are you and Minters Australia seeing at the moment? Are you still seeing the impacts of culture and conduct?
Yes, and can I just echo Abigail's last comment that having a gold-plated policy can actually be counterproductive if you don't actually follow it. So the challenge in putting together regimes to comply with things that have been mentioned, like unfair contracts and modern slavery policies and whistleblower policies and all the rest of it, is it's all very well to have the latest and the greatest policy that's in off the shelf, but if you don't actually have the systems and structures to observe it, you can actually get hung by your own petard. You don't actually, you say you have a policy, but you don't follow it. That's worse, almost worse than not having a policy at all. So it's really kind of trying to work up policies and frameworks that actually work in practice is a challenge. In terms of some of the issues that we're seeing, I'd echo Harry's comments that activity is well down. There've been hardly any IPOs, for example, and the second largest IPO that I was involved with was about a $200 million market cap that normally would be a minnow, but was regarded as essentially a large float in the current market. Secondary raisings are also well down. Public M&A, there's signs of green shoots, but it's still very flat and people are taking much longer to consummate deals. In terms of activity, unfair contract reviews, preparing for stage 2 AML CTF rollout, trying to work out through design and distribution essentially to listed products, listed options, preference shares, that sort of thing can be quite challenging. But essentially, how we sort of see it is a decline, an overall decline in activity, but an ever-increasing regulatory burden on the businesses that are left, and it's really assisting clients to comply with them in a way that's efficient and productive.
And just my point on culture and conduct, is that still prevalent for your clients?
Oh yes, very much so. Yes, it is. Yeah.
Any other thoughts to the panel on that?
I mean, all I'd say is I think part of what is happening is the Royal Commission in Financial Services. I think a lot of that regulation has taken a while to come through, and culture and governance is very essential to that, and that explains in a way why we're at this sort of mismatch between all the regulatory activity and general commercial activity.
Okay. So Harry, what's happening with managed funds in Australia at the moment?
Yeah, so in this environment, arguably one of the biggest regulatory initiatives in Australia, with significant sort of potential impacts for funds management, was announced by Australian Treasury in August 2023, where they released a consultation paper asking for submissions. The date for those submissions closed on the 29th of September of this year. The timing of the consultation paper was interesting, as review was unexpected, I think, in the current environment. But my personal view is that it came off the back of the introduction of the new investment vehicle in Australia, the Corporate Collective Investment Vehicle, or otherwise known as CCIVs. And I think in developing the CCIV, there were many aspects of the existing MIS regime that were changed. So I think Treasury also thought that it would review the existing regime as well. So it's going to be really interesting to see how that pans out. But it's effectively a comprehensive review of our managed fund, or our funds, the way that funds are typically set up in Australia. So the consultation paper posed 24 questions, and the issues were also drawn from a number of previous reviews and inquiries conducted by government that were never implemented. I don't have time to raise all of them, but I'll focus on the ones that I think are probably most pertinent. By far, the question that has attracted the most interest was a review of the financial thresholds for the product value test and individual wealth test for determining whether an investor can be treated as a wholesale client for the purposes of the Corporations Act. Funds exclusively distributed to wholesale investors don't attract the level of regulation and scrutiny as funds distributed to retail investors, such as the registration of funds with the Australian Securities and Investment Commission, and the powers that the regulator has to intervene in respect of retail funds. So obviously increasing the thresholds has the potential of excluding a large portion of wholesale fund managers' existing investors base. That would necessarily affect their business models and strategies as well. And generally, under the current laws, an investor is considered wholesale if the investor invests $500,000 in a single fund, or produces an accountant certificate evidencing that they have 2.5 million in net assets, or have earned at least 250,000 in the immediately preceding 2 years. That's the income tests. So these thresholds were determined around 2002, when the financial services reform legislation was introduced, and on which current legislation is based, and had not been indexed. So it's expected that these thresholds will be increased, or certain assets will be excluded, such as the family home and or superannuation assets. And there are different approaches in different jurisdictions, including New Zealand. And I understand in New Zealand, those thresholds are, I think, 5 million for which are unrestricted, and 1 million for specified products. So the FSC, in its submission, has proposed that the product value test and the gross income test be retained. So that's the $500,000 investment or 250,000 income test, but that the net asset test will be increased to 5 million unrestricted, which is similar to New Zealand, or reduced to 500,000 excluding the family home. So this is a huge issue which will have a huge impact, and particularly in uncertain economic times. And as I understand, so we'll see what happens there. And I think there is a report expected in the first quarter of next year. Other issues raised by Treasury, and I'll do that really quickly because I know I don't have a lot of time. Explicit consent requirements where investors are treated as wholesale clients. I think Treasury is grappling with how to make sure that investors actually agree and understand the implications of being treated as wholesale clients, and they're finding this pretty difficult. Other issues is whether certain types of funds should be excluded or qualified from retail investors at all. You can imagine the general approach to industry is not to impose any more obligation because we have enough. Another, fund governance and the role of the responsible entity, being the trustee of the schemes. Should ASIC be given more powers to direct a responsible entity to change the constitution of a retail scheme, changes to compliance plans for specific schemes, minimum standards for auditors of compliance plans, and whether REs of retail funds should be required to have a majority of external board members. So generally, once again, I think the general sentiment of industry is it's not broke and it shouldn't be fixed, but only refined. Another is changing existing legislation for the replacement of a responsible entity of a retail fund. Currently, it requires 50% of all votes that can be cast, which is quite onerous. Restricting constitution provisions that would disincentivise replacing a responsible entity, like a break fee. Also around whether current definitions of liquidity for the purposes of allowing withdrawals from funds should be changed, and also procedures around winding up. So as you can see, the review is quite extensive, and there have been quite a few submissions made, including a comprehensive one from the FSC, and we'll look forward to hearing from Treasury on that at some time next year. Although I think, suffice to say that I think industry would not be in a hurry to receive change legislation to implement. So hopefully it's a few years away, if at all. Thanks, Carissa.
Thanks, Harry. And just to clarify, that was the FSC Australia submission, not us. Do you think there are lessons to be learned for New Zealand fund managers?
I'm probably not familiar enough with the New Zealand regime to comment, but only to say that I think in the retail space, we are being more and more regulated, and that, but together with the changes in the thresholds for the wholesale test, it's really an interesting inflection point for wholesale fund managers, and that is deciding whether to embark on a retail strategy or an institutional strategy, and that's something probably which New Zealand fund managers are grappling with as well. But as well as I think when it will come to assessing whether fund manager in Australia setting up funds in New Zealand, these changes will necessarily have an impact on their ability to take in New Zealand investors as well.
Thanks, Harry. So turning to financial advice, and in particular financial planners, but can you provide us with an overview of the financial advice regime in Australia?
Yeah, sure, Carissa. So I think there's a very strong dichotomy, as in managed funds, between wholesale and retail, and certainly as far as the regulatory position with respect to financial planners who provide advice to retail clients. The current regulatory regime in Australia has been described by at least one industry participant as peak regulation. In other words, it couldn't get any more tougher. So increased regulation has had some positives and some positive long-term outcomes, which include an infusion of higher education standards for advisors, the creation of a financial planners profession, and the majority exit of conflicted vertically integrated institutions from the advice industry. However, having said that, there are significant negative outcomes. They include complex and duplicated processes for advisors, significantly increased costs of providing advice. The government itself has said that the median cost of advice has increased by 41% between 2018 and 2020. The limited capacity to pass on to especially retail clients those increased costs without affecting affordability of advice. The result has really seen many Australians at or approaching retirement, which some have estimated to be as much as 5 million Australians, effectively having been priced out of any sort of capacity to obtain competent, reliable advice. The other significant negative outcome is a significant exit from the profession of senior experienced advisors. There's been a marked drop in advisor numbers by 38% between 2019 and 2022, 3,000 being 16% of the market in 2021 alone. The government itself has estimated there are only 16,000 advisors left in the whole of Australia. Since the Hayne Royal Commission, over 2,800 advice practices, comprising about 30% of the market, is closed. And the government itself has said that 10,000 advisors have left the industry since the Hayne Commission, which has left a vacuum of quality advice. And so reported and anecdotal evidence is that people are resorting to unlicensed advice, Google or Dr. Google, and scams. At the same time, a third negative impact has been increasing difficulty to attract new entrants to the industry in the face of fierce competition for talent from other professions, including IT, legal, and consulting. Young people don't seek to undertake an advice-related degree. Among other things, the regulatory burden and the risks associated with it are seen as serious negatives for young entrants into the industry. And major institutions in Australia, such as the University of Sydney, the University of Melbourne, University of Adelaide, ANU, and Monash University, don't have specific courses that cater for people who might wish to enter the advice industry. This has been sort of a festering sore that's been going on for a number of years, and the federal government has seen the trends in the industry and is proposing a comprehensive response following the release in February this year of the Quality of Advice Review. And the government's stated policy is to increase the number of financial advisors, reduce the cost of advice, and keep experienced advisors in the industry. So that's their stated policy. There are question marks about the efficacy of implementing that policy through the steps that they're proposing. And there are sort of two urgent steps, and one, there's a down the track step. The first urgent step is streamlining the process of giving financial advice, replacing statements of advice with a more fit for purpose regime, scrapping the safe harbour, which is a complex series of steps as a means of complying with the best interest duty when providing advice to retail clients, and improving transparency about commissions advisors are being paid for certain products. The second urgent focus is changing the regulation of retirement incomes, so making it easier for superannuation funds to give advice to members about how to move balances from accumulation to pension mode. In fact, anecdotally, that's a major issue, that people are actually at or approaching retirement, really haven't got the faintest idea as to who to turn to on how to convert their super balances from accumulation to pension. The other overlay to that is the government's view that superannuation is there to provide retirement income and not to make bequests to family members. So there's always a flip side to a government initiative, and that is that they see superannuation as very much being a means of providing retirement income, not as a way of accumulating wealth for the family. But they do propose steps to provide certainty to super funds on how to collectively charge for advice as well. So actually opening up the capacity of superannuation funds to provide advice in relation to particularly these 5 million Australians at or approaching retirement. The down the track priority is really a fresh look at the role of banks and insurers in providing, being able to and really unshackled from the current barriers on providing more information and advice to retail clients.
Thank you, Bart. And do you think there are lessons learnt that could be relevant to advisors and planners in New Zealand?
Yes, I think one of the lessons would be, and again, like Harry, I'm not familiar with regulation in New Zealand, but avoiding a situation where you've got peak regulation. So in other words, you might have a few less than fully desirable players in the industry, but saddling the whole of the industry with massive new regulatory burdens to such an extreme level that you've actually got mass exodus from the industry clearly shows, in my mind, that the balance of regulation is not at the right level. And anecdotally, I know several advisors, long-standing brokers with decades of experience in providing advice to retail clients who simply can't get their head around the new FSC examination requirements, for example, and just throw the towel in and just leave the industry. They just say, look, I've been doing this for 40 years. I've never had a complaint, but these new requirements forced me to leave the industry. And that would be repeated countless times. And I think one of the lessons learned would be to avoid driving your quality, experienced advisors out of the industry by saddling them with unnecessary regulatory burden.
Thank you, Bart. James, over to you. No organisation is immune to the constant and continual and evolving threat of cyber attacks. What have you observed over the past year, and how have things changed during that period?
Yeah, definitely. I think it's a great point, Carissa, that no organisation is immune. I mean, we've really seen that play out in Australia with some, really significant high-profile cyber breaches. Optus, Medibank, Latitude Financial, a lot of other major Australian organisations have been subject to those sort of cyber breaches and incidents. So it's something that we're seeing a lot of. And I think probably what we've seen over the last 12 months is, I think, really a continuation of a trend that we've been seeing play out for a few years now, which is that cyber privacy and data risk is just a critical issue for financial services businesses in the Australian market. It's not just an issue anymore for the IT team or even the legal and compliance team. It's cyber risk is a fundamental risk issue, and it's even sort of becoming a CEO and a board level issue in a way that probably a few years ago it really wasn't. So I think that's a really interesting trend. I think there's a few reasons for that. I think those high-profile breaches that I mentioned, I think, are a pretty significant driver. Nobody wants to be the next Medibank or the next Optus and sort of have a significant cyber incident. There's obviously a lot of consumer, regulator, and stakeholder concern about privacy and cyber risk. So I think that's driving a lot of it. The legal risks in relation to cyber breaches have significantly increased in Australia. Sort of on the back of some of those high-profile breaches, we've gone from a situation where not that long ago there were no penalties for breaching the Privacy Act, and we've now got penalties of 50 million plus for contravention. So it's a really significant change to the risk profile, and there's obviously the risk of things like class actions in respect of cyber breaches as well. So it's just a very different legal risk landscape than even a couple of years ago. And then there's, I think, the reputational risks associated with having a cyber incident. So I think sort of beyond that, the headline sort of breaches, what we've seen is that, cyber risk is a real priority for a lot of our financial services clients, something they're really focused on, from a compliance perspective, from a contracting perspective, and just from an on-the-ground technology perspective. And I think given the regulator and enforcement action in this space, that's probably a trend that's going to continue. I also think just really the other thing we see is just the challenge of managing cyber risk. There were about 400 incidents on average are notified per quarter to the Office of the Australian Information Commission, which is our primary privacy regulator, and that's just the ones that get notified. So, and it's actually not a super low bar in terms of notification. And many of these are, sophisticated organisations with good plans, with good practices, So, while cyber prevention is a big focus, I think there's also increasingly just a focus on breach readiness, an acknowledgement that no organisation, no matter how much it spends and how much effort it puts into it, can guarantee that they're not going to be subject to an incident. So really a focus on readiness and being prepared in the event there is a breach or an incident.
And how are regulators in Australia addressing this risk? And are you assisting many clients, and what assistance are they seeking?
Yeah, definitely. It's quite consistent with what others have said, because the main way that regulators have addressed cyber risk is with more regulation. So particularly in the financial services space, I think financial services businesses in Australia are subject to a lot of regulation around cyber risk. So obviously the Australian Privacy Act regulates pretty much all businesses, including most financial services businesses. And so there's compliance obligations under that. There's compliance obligations under our APRA prudential standards for APRA regulated entities, including specific prudential standards around cybersecurity, or for standards like CPS 234. For example, we've also got security of critical infrastructure legislation that has specific cyber provisions. So some financial services providers can be caught up as being providers of critical infrastructure. We've had ASIC taking action in relation to financial services licensees not sufficiently managing cyber risks. We've also got a consumer data right / open banking regime that's administered by the ACCC, and we've had the ACCC looking at sort of cyber and digital focused issues from a misleading and deceptive conduct perspective. So, financial services business could have to deal with APRA, the OAIC, Australian Securities Investment Commissions, the ACCC, and Home Affairs, just in relation to sort of cyber issues. So again, really kind of similar to, I think, some of the comments about the heavy burden in terms of regulation. I think what we're also seeing is, regulators are increasingly willing to take action around cyber. APRA, for example, has been stressing cyber as a priority for APRA-regulated entities. ASIC's been taking action in this space, and the OAIC is sort of increasingly taking action, particularly following some of those high-profile breaches where there was a lot of sort of media attention in Australia around, are the regulations tough enough? Was sort of the question that I think was being sort of asked in the press. So, and that resulted in those 50 million penalties that I mentioned. They came about really as a direct result of some of those high-profile breaches. So in terms of the sort of assistance clients are seeking, it's a really broad range. So everything from, assisting with compliance, noting that's a pretty heavy compliance burden, looking at contractual terms when you're doing things like outsourcing agreements, helping out with data response plans, and sort of the worst case scenario, which is responding to a cyber incident or a data breach if that was to occur.
I think in New Zealand, what we've seen, as well as the high-profile breaches that you indicated, there's also been regulator reporting of scams. Do you think there's an opportunity for more industry-led collaboration and sharing of approaches and to address this?
Yeah, definitely. I think, scams is a really big issue. The OAIC, when they put out their data breach reporting, it sort of breaks it down by type of incidents, and essentially scam and malicious actors is a pretty decent chunk every quarter of the number of notified breaches, and that's before you get into things like spam text messaging, which frequently target financial services businesses. So, and I'm sure that's an experience you have in New Zealand as well, where you get the dodgy text message that looks like it's from a bank or your superannuation fund or whoever it might be. So I think there's definitely an opportunity for sort of for some industry-led stuff in that space, because there are some practical measures that can be taken. We're seeing some of them in Australia around particularly some of those spam messaging requirements to basically tighten up who can send sort of some of those bulk messages to try and sort of reduce some of that burden. And I mean, subject to what we say about there's a lot of regulation, some of those things would actually be beneficial, because there's a lot of financial services organisations spend a lot of time responding to some of those sort of scams and fraudulent activity. So anything that can sort of reduce that, I think, is potentially a positive.
Thank you, James. So turning now to when things do go wrong and what's available. In Australia, you have the compensation scheme of last resort, and this is particularly of relevance to our banking members due to the Deposit Takers Act implementation and the Depositor Compensation Scheme. But could you tell us about the compensation scheme of last resort in Australia due to the parallels of what's being proposed in New Zealand?
Yeah, sure. So the compensation scheme of last resort is essentially an industry-funded scheme to compensate victims of certain financial misconduct where those victims cannot recover the compensation they are owed under a determination by the Australian Financial Complaints Authority, or AFCA. So, for example, if there's a financial institution that was subject to an AFCA determination and it becomes insolvent and the relevant insurance of the institution does not cover the complainant's loss for any reason. So an AFCA, in the main, an AFCA jurisdiction extends essentially to retail clients. So it's essentially another benefit for retail clients. It's not available for wholesale clients. The CSLR, or the compensation scheme, was originally proposed by the previous government following or deciding to implement a recommendation of the Hayne Royal Commission. The legislation to do that lapsed, and then as the new government has introduced legislation to essentially the similar effect. It was established in June 2023. However, the CSLR will not be in operation itself until April 2024, and has said it can't start receiving claims before April next year. The operator of the CSLR will be a not-for-profit company authorised by the Minister, and it will compensate consumers for a very narrow class of financial services. So essentially, the focus or the parameters of the claim must be in relation to an AFCA decision made on or after the 1st of November 2018. The claim must fall within a credit activity within the meaning of the National Consumer Credit Protection Act as a credit provider or other than as a credit provider, providing financial advice that is personal advice to a retail client about one or more products, and dealing in securities for a person as a retail client. Notable omissions from the scheme are anything to do with managed investment schemes, dealing by way of issue, and any misconduct determined by a court or a tribunal. The omission of managed investment schemes is interesting because data provided by the Hayne Royal Commission indicated that managed investment schemes in fact have the second highest rate of unpaid compensation claims. So how is the CSLR funded? It's basically funded through an industry-wide levy imposed on financial services providers that provide personal advice on financial products to retail clients, credit intermediation, securities dealing, credit provision, insurance product distribution. The annual levy will be capped at 250 million, and then there are annual levies after that. ASIC has extensive new powers that sort of fit with this new regime. So, for example, it may cancel or suspend a financial entity's license where a levy, shortfall, or late penalty is unpaid. In addition, if there is an unpaid determination that's been compensated by the by the scheme, ASIC can make banning orders against individuals who are involved, either partners of the licensee or directors of a corporate licensee, essentially where the scheme is paid out and they haven't recovered. Any payout by the compensation scheme gives the operator of the scheme a right of subrogation against the firm concerned, as well as any individuals concerned. So obviously there's the potential for double jeopardy, so you lose your capacity to participate in the financial industry while at the same time being pursued by the operator under its rights of subrogation. The other thing to note about the scheme is that there is an overall cap of $150,000 that can be compensated. So it's the lesser of the amount of the claim and the $150,000 cap. The scheme has been roundly criticised on both sides of the fence. Consumer advocate bodies have criticised the omissions of certain financial services from the coverage of the scheme, including managed investment schemes. They've criticised the cap. They've criticised the limitation to financial misconduct determined by a court or tribunal, which removes the jurisdiction of the scheme, and also limiting it to the narrow field of financial services. On the other hand, industry associations have issued a joint media release opposing the scheme, claiming it imposes further unnecessary red tape and increased costs to the financial advice sector, which, as noted, is already hard-pressed with the burden of regulation. The concern is that the current form of the scheme will penalise good and lawful performers to fund the mistakes of bad performers, including insolvent firms.
Thank you so much for that summary, Bart. That was really interesting. Lastly, I am very keen to look at a regime in Australia that New Zealand is anticipating very soon, with modern slavery being introduced into New Zealand at either the end of this year, hopefully, or early 2024. And we also anticipate alignment with the regime. Abby, can you provide an overview of the modern slavery regime in Australia, and in particular, what's changed recently?
Sure. I'm actually just going to share my screen so that everyone can just see. You've disabled participant screen sharing. Okay. I'll just read them out to you then. So Australians had a Modern Slavery Act since 2018. Our clients have been reporting, I think we're basically into the third set of reports. There are mandatory reporting criteria in Australia, which is a bit different to in the UK, which was the act that inspired the Australian Act. And so those criteria are as follows. Describe the structure, operations and supply chains of the reporting entity. Describe the potential modern slavery risks in the operations and supply chains of the reporting entity and any entities it owns or controls. So what that means is that it's necessary if you have an entity that is a holding company, it needs to describe in relation to all of the different entities that it owns, regardless of where they're located. So if you happen to own a mine in Papua New Guinea, you need to describe that as well as your operations in New South Wales, by way of example. Describe the actions taken by the reporting entity to assess and address these risks, including due diligence and remediation processes. So that's the actions taken to respond to the risks that have been identified. Then fourth is to describe the reporting entity and how it assesses the effectiveness of their actions. So are the actions working and how are you working that out? And then finally, consultation within any controlled entities. So it's fair to say there has been a maturing over the past few years in relation to reports. We've gone from looking at reports that were kind of 4 to 5 pages long, where now I at least once a month look at a report that's 45 pages or more in relation to looking at risks. There's been a lot of NGO complaints in relation to what they call paper promises. So the first paper that some particular NGOs wrote was, "You're promising everything, let's see what happens." And the second paper was called "Broken Promises." So there's a lot of concern in relation to adoption of modern slavery and human rights policies, but inadequate real action. So that's resulted in a number of things, but one of them is, as part of the review, there's a statutory review that was undertaken earlier this year. So the Modern Slavery Act had a statutory review every 3 years, so it was a little later than it was meant to occur for a variety of reasons, including COVID, I think. In that review, there was a number of recommendations, and some of them really aim at the fact that this is currently a reporting piece of legislation. So you have to go and you have to identify your risk. You have to identify the risk in your operations and in your supply chains. So that in itself is actually a significant burden, because entities need to go, you need to adequately understand your supply chain in order to do this. And you also need to understand your operations and what you do and where. But beyond that, there's no obligation within the Act to do anything. So you can, if you choose to, but seldom do reporting entities want to do this. You really can say, we've identified all this risk, but we haven't done anything. Typically, there's concerns about not properly reviewing, such that the statement might constitute greenwashing, because there aren't reasonable grounds for the expression of opinion in relation to where the risk is. But there's also concerns in relation to reputational risk, that once you properly describe your risk, you really need to describe the actions that you're taking, or else those people who are reading it will be really concerned. The need to understand supply chain well has resulted in a proliferation of questionnaires and other IT technology type tools in order to understand supply chains better. I think that the obligation to understand your suppliers better is actually a broader issue that's happening across a number of different ESG areas, but in this particular area, it's relatively new. In response to that particular issue, where there was due diligence wasn't really necessarily being done very well and actions weren't being done very well, John McMillan, who undertook the review, has recommended for it to be mandatory for every reporting entity to have in place a due diligence system. So that needs to be in writing. So we'll see what the government thinks about that. There's a view that there should be expanding mandatory reporting criteria. So in particular, if modern slavery was identified anywhere, that needs to be declared. So at the moment, you can identify modern slavery, but it doesn't actually fit in any of the mandatory criteria. You can just say that it's a risk. So I think that will expand to some degree.
Abby?
Yes.
Sorry to interject. How much do the public see of this reporting and identification?
So the reporting is completely public. So there's a register that's maintained by the Attorney General's Department that you can easily access, and you can see what reporting is done. The financial institutions in Australia are relatively in the lead, along with the mining entities, and that's because the mining companies have been working in relation to human rights for a very long time, because that didn't start with the Modern Slavery Act. So there's some relatively sophisticated programs that are in place for financial institutions, particularly banks. I'd say that a number of financial institutions that aren't banks are still working on it. It's likely that there'll be an anti-slavery commissioner in Australia. So a budget has been set for this year to provide some budget for an anti-slavery commissioner. So I think we can anticipate that one will be appointed at some stage, and that the role is unclear, however, in relation to what that individual will do. There are recommendations for civil penalties for non-compliance with the Modern Slavery Act. So there have been a number of complaints in relation to if you don't comply, if you don't report, if your report is not accurate, that there's really no penalty for doing that. And that's often what clients ask when they first find out that they have this obligation. And so there are a number of recommendations for penalties. So there's a recommendation for a penalty if the due diligence system isn't created, if there's a knowingly misleading report. So I think that it's likely there will be some kind of penalty regime that will be introduced, but we'll just have to wait to see what the current Labor government decides to introduce in relation to that. So we are waiting on the response to that. We anticipate it will be relatively soon, but it does sit in a world in which Canada has a new Modern Slavery Act that reports first next year. New Zealand, as you know, is looking at what its Modern Slavery Act should look like. There's an EU draft directive in relation to sustainability. So it's really going to be looking at it from an Australian perspective, although we were relatively first movers, it's going to be a tidal wave where everybody basically needs to start working all of this out. In relation to trends that we're seeing, the first of all is setting up proper corporate governance. So board level strategic decision making, responsibility in the board, pick a board committee that has responsibility. The board needs to understand the programs. We usually see a modern slavery working group within our clients that are drawn from a variety of different parts of the entity, from HR, from compliance, from legal, from procurement, from government relations. And government relations is actually relatively important because a number of Australian government entities have expressed a desire to take supply chain due diligence very seriously, none more than the New South Wales government, who have their own anti-slavery commissioner. We're seeing policies. In the first year, we really saw a proliferation of policies. So that's really important, but absolutely implementation of your policies are key. So if you've adopted a policy that says we will have a zero tolerance for modern slavery, you really need to go and do something. So you need to explain to your procurement team how it is they do that in a world in which for the rest of their practice as procurement professionals, they've been asked to keep the quality the same and reduce the price each year. And now they're being asked to manage the risk of modern slavery in their suppliers. We're seeing continuous engagement with suppliers throughout the life cycle. So it's no longer a set and forget. And that's particularly the case if you are engaging with any of the very large Australian companies. We do have clients who are suppliers to large financial institutions who are receiving papers that are instructing them in relation to how they would like them to improve their ESG performance policies, procedures, implementation. So that is a supplier life cycle trend. There's definitely a move to try to understand risk beyond the first tier of the supply chain in relation to high risk suppliers down the supply chain. There's a lot of interest in relation to adopting a living wage commitment. So an agreement to pay everyone a living wage who is within your workforce, regardless of where they work. Freedom of association, the prohibition of recruitment fees, because recruitment fees are a significant driver, particularly in second and third world markets of modern slavery. And a lot of collaboration. So there is really an interest in trying to tackle this as a group. Everyone knows that this is not something that one particular entity can do.
Thank you, Abby. And do you think New Zealand organisations should be starting to work on this now, even before the legislation is rolled out? And if so, what do you think would be the key lessons valuable for New Zealand organisations facing this change?
It seems to me that it's inevitable you'll get something. So my first advice is yes. The second advice really is that you need to work out your corporate governance piece first, which is who is responsible for this, whose KPI is it. This needs training. So you're not automatically going to have capability in this space. So you need to be looking at a program that teaches people how to do this. Your policies and procedures, your supplier agreements, RFT processes, all of those need to be looked at. A gap analysis at the beginning is a really good idea. Work out what do you have and where. You can't ignore your own recruitment and your own employees, making sure they're all right. And then also trying to find a peer group that you can participate with to try to resolve issues together.
Thank you, Abby. And this will definitely be something that FSC New Zealand will be keeping a close watch of, not only in our Climate and ESG Committee, but also our regulatory response to the bill when it lands. So definitely keen to keep engaging with you on this topic. And if you are keen to continue your Trans-Tasman awareness, we invite you to check out our website because we are having an upcoming Trans-Tasman Strategic Leaders Summit. That's from the 4th to the 6th of March in 2024 at the Quartus in Auckland. So this is a first for FSC New Zealand as we combined with FSC Australia to bring the sector a Trans-Tasman event featuring politicians, regulators and key sector experts to discuss big and current issues of the day. And we encourage you to register and come along as an opportunity to connect the New Zealand and Australian sectors of the wider international community. So please have a look on our website and check this out. That brings our webinar just about to a close. I'm just having a look in the chat, and we haven't had any questions through today, but I think we have covered a large amount of ground. So a huge thank you to Abby, James, Bart and Harry. It's been incredibly interesting. It sounds like there is a lot of similarity with the regulatory burden and overload in both our countries. So I hope everyone who's joined today has found this webinar insightful and informative. It will be available soon on the FSC's YouTube channel. So any last comments from any of our panelists?
I'd say good luck.
Thank you, Harry. All right, I will give you 5 minutes back in your day. Thank you so much, everyone, for joining us and our panel, and have a great afternoon.